All right. What am I doing wrong?
You're fine. Should be
What
on.
am I doing wrong? It's not on.
I will call Justin. It is not. Could be if they have the volume up. Maybe I'm not sure.
Okay. That is weird. Now it's not working. Okay. Shoot. One, two, three, four, 5, 6, 7, 8. Oh, good. We got quorum. Okay, ladies and gentlemen, we're going to go ahead and get started. We're running a little bit late today. I do apologize. I try to be respectful of everybody's time. We do have a slight change to the agenda. We're going to be also, in addition to the two bills that are on the agenda, we will be hearing House Bill 1022. That will be the third and final bill that we'll address. The first bill that we plan to look at is Chair Gunter. Will you step forward, please, and present your bill?
Okay, there we go. All right. All right, Madam Chair, members of the committee, thank you. If it's okay, I would like to ask for Judge Clow to come up with me.
Sure, that's fine.
He can probably provide a lot of better answers.
If you wouldn't mind, just start us off, kind of walk us very briefly through the bill. We'll let anybody answer any questions, and if any of the specific practitioners or if any of the committee members have specific questions, then you both can answer.
Okay, well, generally speaking about the bill, this is a bill to bring the juvenile courts under the Council of Accountability Courts to standardize what their treatment is, and also to gather data as far as how successful they are, but mainly I think to get them under a standard that's already been used across the state. I'll call on Judge Clow at this point to go through the bill. He is a lot more intimately aware of juvenile court procedures and what the meaning of this bill is.
Okay, all right,
Right.
Judge. I will, just to make you aware, some people are listening to this online, so we do have to talk into the mic so they can actually, I'll start getting texts from folks. I can't hear the witness, so if you wouldn't mind, just speak to the mic, please. Thank you.
Madam Chair, committee members, thank you for hearing from us today. The language closely tracks the Superior Court accountability courts, such as drug court and mental health court. We have had juvenile analogs to those, juvenile mental health courts and juvenile drug courts in Georgia for over 20 years, and those have been funded by the Council of Accountability Court judges since its founding in 2015. Right now, depending on how you count it, we have either 17 or 18 of these courts currently in operation. They are funded, but there's not really any significant oversight over them at this point, and that's what this bill would change. What this would do is codify this class of courts and provide for a certification process, to provide for standards that all of the courts would have to follow, peer review process, and provide additional training for practitioners. The goal is to make sure that everybody is following best practices and that all of the children are getting the services they actually need to make a difference in their lives.
Okay. All right. I am very familiar, intimately familiar with the inner workings of the accountability courts. For full disclosure, my husband actually runs a vet court in Cherokee County, so I'm well aware of the ins and outs, and actually I serve on his steering committee for that. Could you just walk us kind of briefly through the bill as far as what are some of the parameters? What does it mean whenever we're codifying some of this and we're making some of that for some of our committee members who might be a little less familiar?
Okay. First thing is there's 3 classes of cases that appear in juvenile court. One is dependency, that's defects or child welfare cases. The other is delinquency, which is what we traditionally think of with juvenile court, which is children breaking the law. And then there are CHINS cases, which are where a child commits an act that would not be a crime except for their age. That's the old status offense classification. About 10 years ago, we broke that out into its own category because that kind of fills a gray area between criminal law and child welfare. And so that's things like unruly child, truancy, possession of alcohol under the age of 21. And what this bill would do is it would provide for accountability courts that serve children in delinquency cases and CHINS cases. The Section 2 of the bill covers that, and one of the concerns that we heard earlier in the process about including CHINS cases in this is the committee that drafted this thinks it's important that these services be available to CHINS children. As a classification of cases, CHINS are typically symptom cases as opposed to problem cases. If a child is not getting to school regularly, there's something going on underneath that. It's not typically just a school thing. And so we think it's important that children in that classification have the opportunity to go through a program that will actually address whatever underlying issues have brought them there. One of the concerns we heard, though, is that some judges might perhaps interpret this as increasing their ability to incarcerate or penalize children in CHINS cases, which is statutorily not permitted at this time outside of the exercise of the court's inherent contempt power. This statute would not change that at all. There would be no additional power to incarcerate beyond what is already in the statute. There's a list of goals of what we would like to see these classes of courts accomplish: reducing drug and alcohol abuse, addressing behavioral health. That goal is very similar to the adult courts, with the exception that we also covered gang involvement. Line 48 deals with how a child gets into one of these accountability courts. The initial draft of the bill said that it would be contingent on the agreement of the prosecuting attorney if they came in either before or after adjudication. The subversion which you have allows the prosecuting attorney to make that decision prior to adjudication, but not after adjudication. After adjudication at the dispositional phase, that would be up to the court's discretion. And that closely tracks the way the statute works now. Unlike Superior Court and juvenile court, if a child is found delinquent, the court then has to make a determination about whether or not that child needs treatment, care, rehabilitation, supervision. The state can prove their case beyond a reasonable doubt. The court can find that the child committed the delinquent act but doesn't need any treatment and simply dismiss the case. That's the status of the law right now. And so the court's authority post-disposition is quite broad. And we believe that this both tracks the court's inherent authority to handle how the case will be managed after an adjudication, while respecting the state's decision about whether or not they want to proceed on a case prior to adjudication. That's why the state's decision is still there prior to adjudication, but it's solely the court's determination after that. The next section of the bill deals with the planning committee and then moves into standards. The standards have not yet been developed. Should this bill pass, the committee on which I serve that drafted this legislation has been reconstituted, and we would then set about the work of creating the standards by which the courts would be bound. Those standards would be developed, as this legislation was, by a working group of practitioners. We had service providers, we had a public defender, we had a prosecutor, we had the court. We had basically the full panoply of people who'd be involved in the program were part of writing the rules, and I think that's the best way to do it, is to let the people doing the work basically canonize the right way to do that. There was one of the sections that's missing in your substitute version is an earlier draft of the bill had a provision in that would allow courts who have this class of court to seek additional funding for senior judges to help handle their regular calendar while they're attending to duties for one of these classes of courts. That funding mechanism still exists, but it exists outside the CACJ, and so we remove that language from the bill. That doesn't affect the court's ability to get additional resources to help pay for judicial resources as needed. On the 5th page, beginning around line 103, it deals with data. Data collection is one of the most important functions that CACJ performs. And I'm not saying that to make light of everything else they do, which is substantial, but if we talk about best practices and best outcomes, we need to know what we're doing and we need to know how well it works. And the way to do that is by tracking the data of what exactly goes into every program and what exactly comes out. And that's an important part of the standardization process, is seeing to it that everybody's providing services. If drug screens are needed, that they're providing them in an appropriate way, at an appropriate number, that we're actually getting reasonable results, that we're tracking what they are, and we're tracking at the end of the program how well it's worked, and so we know where we need to course correct or where we're doing things right. (138) brings us more into the process of how people, line 138, which is on page 6 of what I've got, brings us through the criteria of how people would come into the program. Those, like the standards, will be developed as we go. They will be objective, is certainly my intention. I think that's the best way to do it. Certainly everything that we've seen in the other accountability courts shows that objective criteria are a critical part of the process. Near the bottom of that page, around line 147, 148, there's a clause, and this is lifted pretty much in whole cloth from the other accountability court statutes, about what can be done with the data that's collected as part of the program. Specifically, that evidence of positive drug screens and abuse and of statements by that child would not be admissible against them outside of the either drug court or mental health court context. And what that is it provides the child the opportunity to participate meaningfully and to be honest, to do their best. And if they don't succeed, the fact that they didn't succeed and why will come into the record later. But every specific thing they said about what they did, every different drug test they had, all of that would be walled off, and that would not go to the finder of fact afterwards.
Okay. All right. Thank you very much for that presentation. Let's see. Witness Mike 8, is that you, Representative Oliver? You're 7. Okay. Representative, you're 8. Okay.
Thank you,
There you go.
Madam Chair. Good afternoon. Thank you for coming. I'm thoroughly confused right now because we have met at least 5 times with the Council of Juvenile Court Judges because CHINS doesn't happen anymore. I was CHINS chair in Gwinnett County for 8 years, 6 in Jackson. And from what I understand, when I left, it stopped. So is CHINS actually happening? Because if it is, we've wasted a lot of time.
We're still having CHINS cases, and I think we probably have some going on in my circuit while I'm absent today.
Y'all need to talk. Because we've met at least 5 times in person to talk about CHINS and how to revamp CHINS because it doesn't happen anymore.
I'd certainly be happy to talk with you about that. I think it's an important class of cases.
Absolutely. Second question is, where you said something about training for practitioners were in here somewhere. I can't find that part.
There's not a specific reference to that. It does talk about technical assistance, and that would include training for practitioners. One of the things is there's been a question about whether those practitioners are able to attend the annual conference, the CACJ conference that happens in September every year, because their courts aren't certified and don't have to follow all the rules. Are they able to expend those resources beyond just paying for the services themselves? This would clarify that.
Okay.
All right. Okay. Thank you. Representative Oliver.
Thank you for coming today. Tell me again where you serve, what circuit?
I'm in the Enoda Circuit, which is Towns, White, Lumpkin, and Union counties.
The mountains.
Yes, ma'am.
I hired him a long time ago. I did good.
I'll be more respectful then. Thank you. Important area of the state. I have a follow-up question about CHINS, but before I do that, you have been talking to us about 481127S. This is the substitute that's in our... And has this substitute been public in any way? Has this been circulated to anybody that's at... Is this
Is
a- is this a-
anybody here that doesn't have a copy of the sub? Okay.
So it has been, it's out before we came to the...
Yes,
okay.
ma'am.
There is an ongoing discussion about CHINS, where it exists and when it doesn't, and there's some understandable confusion, I think, about that. It's confusing in my mind, anyway. In adult accountability courts, does the the adult offender, consent to participate in adult accountability courts?
Yes, ma'am.
I don't
It's-
see that you have a provision that a juvenile consents. And was that intentional, or was that something you didn't think about?
We did think about that. We're happy. I think that language would be appropriate to be included. Most of the accountability courts are consent-based. Some of them participants can be ordered into. In family treatment courts, for example, there's a split among the judges. Some will order somebody into it, some will not. This class of court we specifically think should be consent-based, though.
So you would not, Chairman Gunner, would not object to requiring the consent of the participant?
No, not at all.
And just to Legislative Council, if I may choose to offer that.
Legislative councils.
Legislative Council,
Please.
you can tell me exactly where it might be appropriate, because I'm looking at some notes from the earlier version. Thank you. Thank you.
Okay. Does anybody have any other questions for the bill's author? I do see that we have, it looks like Gactel, Maisie Lynn, it looks like you're the only one that signed up to speak on 873.
Good afternoon, Chairman Ballinger. Thank you for hearing from us today. I'm Maisie Lynn Gerton, the Executive Director at the Georgia Association of Criminal Defense Lawyers. I'm joined by Randy Waldman, who is our most recent chair of Gactel's Juvenile Justice Committee. And we are really grateful for having had the chance yesterday to interact with the council's general counsel to give some feedback on this legislation. Some of it we were able to come to some agreement on and have seen it reflected in this new sub. Some of it, though, we would just like to bring to your attention because we were not able to come to terms on it, and just so that you can consider some of the policy matters that we find still worth discussing as this legislation moves forward. As a threshold matter, as you heard from Judge Clow, this language does closely track the adult language, which is helpful for all those of us who are dealing with drafting issues, but it's also potentially a hamstring when you're trying to craft a juvenile system from an adult system. As Representative Oliver was raising her question about consent, there are some differences and some similarities around how these processes might want to work. For instance, one of the changes shows up at line 33 in the sub, wherein this legislation would disallow the extension of a court's ability to incarcerate a child. We believe that is a response to our concern that a child who, for instance, a child in need of services, a CHIN's child, would never be subject to detention in the court proceedings that they are involved in today. But in a treatment court setting might be sanctioned with detention. The concept of incarceration is it's an adult court concept. In the juvenile system, we have different forms of detention. In fact, Ms. Waldman, could you say more about the different types of detention? But that's one example of how we remain concerned that language doesn't go quite far enough to prevent, for instance, a CHIN's child or a child whose delinquency offenses wouldn't otherwise expose them to any kind of detention through the normal delinquency process, potentially being sanctioned in the treatment court with some form of detention, which we know has happened in the courts that exist today, and we would like to see that stopped. I believe we could come to some language that could be a compromise, but we are not yet sure that the language at line 33 quite does that. And we did provide some language that we would be happy to provide the committee today too. We are grateful for the changes that were made regarding the lack of need to have the prosecutor's consent to a pre-adjudication entry. That is definitely a compromise we are grateful to have gotten, as well as a provision of the child's records to their defense counsel should the child not complete the treatment court program, which is a modification that was made in response to our concerns. When we look to what is now lines 136 and 137, this subparagraph B is discussing some of what can happen when a child successfully completes a treatment court program, and it only allows that their successful completion may provide for the dismissal of the charges. We would respectfully ask that if a child successfully completes the juvenile treatment court program, their case be dismissed, and make the may a shall there at line 137. Another legacy piece of language at lines 139 and 140, this idea of a NOLO plea is not a creature of juvenile court. It could just be, I forget the word that means you have extra words that don't really matter. There's a word for it. Yes, thank you, friends. It just seems like you could strike that sentence beginning at any and going through to court on line between lines 139 and 140. And the other, there's two other kind of larger pieces of policy that we raised that have not yet been incorporated, and we haven't had a chance, in all transparency, to have the next conversation, right? We had the conversation of, here are some ideas, and then there were conversations that had to happen to consider those ideas, but then the here's what we can and can't do conversation hasn't quite happened. Except for that, we see that some of our suggestions weren't at all incorporated. So I'll take that as them being undesirable or impracticable. I'm not sure. But to the extent that a child participates in a juvenile treatment court, this is not a line. This is just a policy consideration. I might put it, though, if I were putting it in a line, as a new subparagraph after C on page, line around 149. The concept that the child get credit for any time they spend in the treatment court and have that credited to any future disposition should they fail to complete the treatment court. You've heard today that these treatment courts can take 12, 18, up to 24 months. And if a child gets some substantial progress through the court but isn't successful in the end, we would like to see that, whatever it is, 6 months, 9 months, 12 months, credited to whatever disposition were to happen later in the delinquency track that they would fall back to. Then, as another matter of policy, we are concerned about the idea of charging children to be in a treatment court, and this would be found at lines 160 to 162 in the sub. We did provide some language. We understand that there is a need to have the language that is here at 160 to 162 in order to avoid monies being rerouted to someplace other than the treatment court, should they ever come in to the treatment court. We're happy for the treatment court to get all the money, all the resources that it needs, because I should have started here, but we want this to happen. We want standardization. We don't want the children in Fulton being treated differently than the children in Toombs. We want standardization. We welcome the training that this would bring to defenders across the state. We like so much the devil's in the details of how you lay out the standards and practices in statute, and that's why we raise these arguably nitpicky concerns. So we understand that the lines in 160 and 162 are necessary. We do have language that we've offered regarding the disallowance. So the idea that treatment court participation shall be provided at no cost to the participant, and keep the lines that are there. Essentially, any monies received by a juvenile treatment court division for treatment and services shall not be considered a court cost or fine. So those are the large buckets of policy matters. If you had any specific practice questions, Ms. Waldman is the frontline youth defender. I've never been a youth defender, and I've only practiced in adult court, so not as helpful.
Members of the committee, any questions? Seeing none, thank you.
Okay, thanks.
Oh. Okay,
Thank
never
you.
mind. Somebody will follow up with you offline. Does anybody else wish to be heard on House Bill 873 that we have not heard from? Chair Gunter, I'm sorry. You have a question? Okay. All right, I'll clear that. Representative Oliver, you have a question?
I would like to ask Judge Gunner whether he has a reason to, on line 137 of the substitute, to keep with the word may instead of shall. What's the policy behind not directing that the charge be dropped if there's a successful completion?
Okay, well, my familiarity with the accountability courts is as a Superior Court judge,
Right.
and there's enough differences in the juvenile law that's why I brought Judge Clow here, so I'm going to defer to him if he doesn't mind.
Well, and I wanted to kind of tack on to that, and I was wondering if it had something to do with whether or not it was pre-adjudication or post-adjudication, depending upon how the charges were being treated. So,
I don't know that we've specifically contemplated it in that context.
Okay.
I believe some of the other, I practiced in mental health court when I was in ADA, and I seem to recall that they had the same practice there. Some cases it was dismissed, some cases it would not be.
Mm-hmm.
I think it's best to leave that discretion to the individual program, how they'd like to handle those cases. I
Okay.
think if we make it shall, that's probably going to shut the door to some children that prosecutors or whoever simply are not willing for them to have their cases dismissed, but they do want them to get the treatment. And so they might agree to, say, a non-carceral sentence and a treatment program,
Mm-hmm.
but they wouldn't agree to that if there's not going to be anything at all at the end of it.
Okay.
And so I think
That's
it
what
makes
I
sense
was.
to allow them the flexibility.
Yeah, that was kind of where I was going with that, but I'm glad you were able to clarify that and put that in much cleaner language than I could have. Would y'all like to respond to any of the other concerns that Maisie Lynn brought forward from GACDL?
In terms of the credit for time served concept, I don't have
Mhm.
any opposition to that. I think
Okay.
that's reasonable.
Okay.
In terms of collecting fees, that's also kind of a split practice among the other accountability courts. Some choose to collect fees, some don't. In the
Okay.
adult context, that's typically because they seem to see better outcomes when people put some amount of money, even if it's not a large amount of money,
Mhm.
certainly not enough to pay for their cost.
Yes.
But they seem to get better buy-in from that.
Mm-hmm.
This is not something that I would necessarily pick as a hill to die on,
Yeah.
but it does make sense to me that you might want to leave that option open for some cases. Let's say you've got a teenager who's in a program
Okay.
who is working,
Mm-hmm.
can provide $10 a month,
Mm-hmm.
whatever they think is appropriate to get added buy-in for that.
Okay.
I think it makes sense for them to have that flexibility if they want to do it.
Okay. All right.
And I want to say that
Mhm.
in the adult system that I was in, I used getting a job and paying your fees as part of the treatment as people came through my program.
Mhm.
So, and I thought it worked very well.
Okay. All right. Representative, you had a question?
Yes, thanks. Well, I'm just deeply concerned about chins, and all of the conversations we've had over the last year or so has been that it's functionally not in existence. And for those of you who don't know what CHINS is, it stands for Children in Need of Services. It's kind of a diversion program. If it's a statutory offense, it's that's the conversations we're having. And where I was chair, it was dropped completely and went to the CHINS committee. Therefore, the child never sees the courtroom, never sees the judge, and that was the concept that I believe in. And this seems like it's relying a lot on CHINS, and to me, CHINS is not functional from what we're hearing. I would, at the appropriate time, would like to move to table until we can get the answers to some of these questions. For me, particularly, CHINS I would like to have that more concrete before I would vote yes on this.
Okay, and I appreciate that concern. Just for clarification, this is the posture of the bill. I'm prepared to move the bill today. We are getting a little late in the session, quite frankly. That is, if we can get, there are kind of parsing some of the needed amendments. There was, upon the consent of the juvenile, would obviously need to be added at lines 52. To address the concern that Representative Oliver had. And there was obviously the final concern at lines 160 to 162, just to kind of broaden that. That would be the, I mean, I'm not making light or dismissing those, but this is a good program. I think we need to move forward with it. I'm not saying that there aren't some issues with chins, but I think that to not move forward with a good policy for the state to address something else is, even though, anyway, I just don't think that's a good path forward. For my own mind, I'm happy with the May, given the discretionary nature of that. So that would not need to be addressed. But if those two things could be addressed in the form of some amendments, then I am prepared to move this forward. However, if that's not, if y'all have places to go and people to see and that sort of thing, if that's not amenable, if y'all don't want to kind of, powwow together and come up with a couple of amendments. If y'all don't want to do that, then we can deal with it offline and we can come back on Monday and try to deal with it then. So,
Madam Chair, we're okay with the amendments if
Okay.
y'all want to go forward with it.
okay, all right. Why don't y'all get together with some language for Ledge Council so that whenever there is a motion due pass, there are prepared amendments ready to be offered at that time by one of the committee members. So just make sure that language is tight in there and that we have the appropriate line references and that sort of thing. So, sound good? Okay. All right. Thanks. Representative Oliver, you had a question?
At the appropriate time, I was prepared to make a motion, and I have the language for the consent provision. I'm just not sure where to put the time served provision. That's. I think those are the two things that we want to move forward on. I just. But however, the chair wishes to proceed.
Okay. Do I hear a motion do pass
Move to pass.
for House Bill 873 LC 481127S? There's a motion. Is there a second? Second. There's a motion and a second. There are two amendments, I believe, coming. Representative Oliver, you're recognized for the amendment.
I'm very happy for legislative counsel to correct me, but I think the amendment and consents to the participation should go on line 47 after the word division and comma. That's where I would put it. So that the line would read eligibility criteria for the juvenile treatment court division, comma, and consents to participation, comma, such case may be assigned to the juvenile treatment court. If that's the amendment I offer, Madam Chair.
Okay. There is a motion for an amendment. Is there a second? There's an amendment and a second. All those in favor of the amendment, adding the words so that line 47 will now read eligibility criteria for the juvenile treatment court division, comma, and consents to participation. Such case may be assigned to. Is how line 47 will read after this amendment. There is an amendment and a second. All those in favor of this amendment, please signify by saying aye.
Aye.
Any opposed? Okay.
The second amendment, credit for time served, is I'm struggling where that might be, and I'm open to any suggestion that the judge would like to make.
Around line 149, that's the end of the paragraph that talks about unsuccessful participation.
Mm-hmm.
I'm envisioning something that simply says, any time spent in a treatment court, child shall be credited with any time spent in active participation in in such court program against any future disposition in the same matter.
Madam Chair, I offer an amendment of the following line, following line 149, a new sentence.
Okay.
And I'm happy for you to say that again, sir.
Representative Oliver is, I believe we're going to
Child
recognize.
shall be credited with,
Any time actively participating in such program against any future disposition in the same matter. And the reason I said active participation is if a child signs up one day and disappears for 9 months, then gets picked up on a warrant or some other cause, comes back in the court, he shouldn't get credit for the 9 months.
Yes.
But he should get credit for the time before that.
Yes.
I think that encompasses what our intent is. Thank you.
Thank you.
So I'll offer that as an amendment, Madam Chair.
Okay. So we are now, those concluding the amendments that we have, we now have, we are back to the original question, a motion.
We still need to vote on the amendment.
Oh, I'm sorry, we need to vote on the amendment. So all those in favor of that final amendment, giving the child credit for time served, at lines 149, all those in favor of that amendment, please signify by saying aye.
Aye.
Any opposed? Okay. That motion carries. So we have two amendments. I think having just voted on them, I think we'll dispense with reading them. So we're going, okay. You have a question? Okay.
Yes, Madam Chair. On line 162, they wanted to look at, make it known that the program cost is free to the participants. Did we address that amendment?
No, we were not moving forward with that amendment. No. That was one of the things that will be able to flex based on the participation of the individual juvenile. So, okay. You had a question?
Thank you, Madam Chair. What about the suggestion to get rid of the line at 139, any admission or plea of nolo? To strike that sentence?
We were not moving forward on that one either.
We're not moving forward?
I may need to copy back at some point.
Okay, so we have the motion to pass on LC House Bill 873, LC 48. Okay. All right. Last question.
Oh,
Oh, okay. Okay, we have motion to pass House Bill 873, LC 481127S with those two amendments that we just voted on. All those in favor of the passage of the bill as amended by committee, please signify by saying aye. Any opposed, like sign. Okay, all right, hand vote. Who's opposed? 1, 2, 3, 4. Okay, all those in favor?
2, 3, 4, 5.
5. Okay. Motion carries. Congratulations.
Thank you.
Thank you.
All right. The next bill up is House Bill 993. Chairman Powell. Thank you. Chairman Gunter, if you'll get me that form, I'll sign off on it for the rules form. Okay. The floor is yours, Mr. Chairman.
Good afternoon, Madam Chairman, ladies and gentlemen of the committee. I bring to y'all today House Bill 993, and I'd like to give a little background to this bill. This is something I've been wrestling with for 3 years, and have been reaching out to the legal community. And this stems from an incident that happened in my area. There was a young lady, and all of this is, and I'm not taking a position of whether the charged was guilty or not, because it's still pending. But there were some issues that came up that dared to get my attention. We had a young lady that was 11 years old, and there was a coach that supposedly showed her an abundance of attention at a YMCA and such. And this attention went forward until the girl turned to the age of 16, and then there was a sexual encounter. And this went on for a while, and then this somehow broke apart. But at the age of 18, he was charged with rape, or statutory rape, or whichever. And at that time, the young lady was so distraught that when he was granted bond, that she committed suicide. And there was no witnesses at that point to this. Now this goes forward, and I'd never heard the word grooming before. But apparently in the communities that people have gotten involved, this is a common term for adults that cultivate children for sexual purposes at some point. Now, when I say that I had, for the last 3 years, I've been working on something, and I reached out to members of the legislature who were skilled attorneys over in judiciary and such, and to the prosecuting attorneys council. What is something that we could do? Because first and foremost, I still believe that you're innocent until proven guilty. And I certainly didn't want to pass anything that would throw cold water on civil behavior of someone being nice to someone. And the first bill that was put in last year that we wasn't able to move, it was basically sentencing, more harsher sentencing if found guilty of any sexual behavior. And this year, thanks to Chairman Smith, and I think maybe Chairman Gunner had spoke with Chairman Smith, and maybe they came up with an idea, and that's the product of House Bill 993. The gist of this, and the way I read it, it gives a definition for grooming on lines 1 through 15. And then 16, it's the person commits the crime of grooming a minor when such person makes contact with a minor to establish trust with the eventual objective of arousing sexual desires with either minor of the minors. And it appears to me that what this bill would do, if passed, it would make that a felony to groom with the grooming, with the definition of grooming. But this would also be a secondary charge once an offense, a charge has been made for rape of a minor or something like that. And that's the gist of this bill. This has been a very difficult deal for me to deal with. One is that, something I'm quite frankly unfamiliar with. But in this day of sexual exploitation and a lot of this, we all know to guard our children.
Mm-hmm.
And that's what this bill does, ladies and gentlemen.
Okay. All right. Ladies and gentlemen, any questions from members of the committee? If you'll hit your button as much as you can. Oh, all right. There we go. We'll try. See if it works.
Sorry, I'm technologically amped over here. So I had a question about, two questions. What is the crime that is closest to this bill? And this might be a question for PAC. And then the second question is, I'm trying to make sure I understand what the elements of the crime would be in order for a prosecutor to prove it. Making contact, and I'm just talking, making a contact with him, and then the prosecutor would have to prove that the contact would be to establish trust, and then third element, I guess, would be with the eventual objective of arousing the sexual desire of the minor. And I'm trying to see how hard would that be to prosecute, and I'm just thinking, I don't know.
Being a non-attorney, I'm thinking that probably there would have to be the charge of rape or something such as that would have to be levied. And then in the investigation, if they went back and this person or whoever it may be, if there could be evidence given that they had actually been moving forward from a younger age, showing special attention, gifts, this type of thing. All of those things would be evidentiary that, then they could possibly be charged with this crime. I mean, that's...
Can I ask a follow-up question?
Sure.
So, so the goal for this not to be a standalone charge, it would only be in addition to like rape or sexual assault or something
Correct.
Like that. It wouldn't be
until there's been a sexual act perpetrated. I don't think there's a crime that could be committed. But then once that crime has been committed and charges drawn, then they could go back and look at these other behaviors.
Okay. All right. You had a question?
Yes, Madam Chair, thank you. Just a real quick question to my friend. On line 13, and I'm kind of putting my old school board hat on, a lot of times in situations there are, thank God it was very rare, but when it does occur, these tend to kind of start out kind of in a low, and then it becomes a problem over time and with greater intent. So I like your train of thought here where you term it sexual abuse, manipulation, exploitation. Did you ever contemplate sexual harassment? Because sometimes it doesn't necessarily go as far as a traditional term of what I think a court of law would term rape, but harassment of a minor if you're a coach or a teacher or an employer or whatever the situation might be, where that adult has some type of, fiduciary oversight over that person, that harassment is just as detrimental to a child and a young person, but it may not meet the threshold. But a 1-year sentence, if a prosecutor can prove that and might not be able to prove something else. I know in situations we've had school employees, again rare and unfortunate when it happens, that have not been able to be prosecuted, but there was enough evidence for them to lose their license and go through the Professional Standards Commission and then have a revocation of their teaching certificate, or even some cases where they were a coach. Are you amenable to considering harassment? Does that add merit, or does that cause an issue for you as the officer?
I'm very positive of the committee process. These are issues that y'all certainly would know better than I. Never served on a school board. Matter of fact, we dispatch in my earlier life, we dispatch criminals like this in a different way. And I don't mean to be flippant when I say that. In this day of things that are coming out about sexual exploitation and things like that, those of us who are pretty well considered country and redneck, these things are all new to me. I mean, not that it's new, but these things do happen. And, this thing about grooming, I'd never heard the term grooming up till this instant. It was made an issue in our community. Beautiful young lady. And then once it came out that she had been having a sexual affair with a grown man, or supposedly had, and I say that because it's still pending, but because of it, she committed suicide. I tell you, this is a very devastating issue, and I think that in this day that we're trying to do all things possible. So at the will of the committee, to answer your question, I bear to the will of the committee. Y'all are the professionals. You come to regulated industries, I can tell you about all the regulating and stuff like that on other
You can tell us
issues.
all about beer.
Yes, sir.
Alcohol, gambling, anything like that. But in this, it's a different area.
To the chair and other attorneys, but
Okay.
whatever you think.
All right. We'll certainly contemplate it. Representative Oliver.
You just said that this offense of grooming as a new offense would be contingent on a conviction of a sexual act. But I can't, did I misunderstand you on that? But it's not, I can't see in the bill where it is contingent on the groomer being convicted of some sexual act. Is it your intent that it be?
Again, I will tell you, I may be one of the very few non-attorneys in the legislature that says he's not a non-attorney. But the way I read this, and in common sense terms, a DA might could charge you with grooming. But how are they going to prove it's grooming unless there has been the actual crime of an offense such as rape?
That would be in the discretion of the DA, but I don't think it's accurate to say that it's contingent on a conviction.
Possibly.
So I just wanted to clarify that. I would be opposed to, and I'll tell you why, adding sexual harassment. Sexual harassment in most contexts is a civil action, and criminalizing a bad act, a civil action, criminalizing that is something that is maybe a bridge too far for me.
Involves children under the age of 18.
Well, but I think at that point it would rise to the level of child molestation.
it may or may not rise to the based on facts of child molestation. I think the reason I would is that then you get into the area which is frequently a part of our discussion about offenses against 16-year-olds by 19-year-old boys. That's part of the murkiness right there. I don't want to criminalize teenage bad behavior that is under an umbrella of teenage bad behavior or civil acts of harassment.
I appreciate the lady, and I definitely am not an attorney, but I'll say this. I read this as to look at the term of grooming to encompass an adult's interaction with
Yes.
a non-adult for the person of an emotional connection with a minor to gain that minor's trust for an objective of, and I do think that if you are an adult and you are 19 years old or older, and I think there are more cases in which the harassment piece, there's a much greater difference. And in my experience, I can tell you that if there was an opportunity for us, if this were in the case in a law, it would have been a lot easier for us to fire and refer a teacher to a DA versus just hoping that PSC would take the merits of the case and either do a temporary revocation of a teaching certificate for that person who may or may not ever end up being charged in court of law. But I just am a believer that harassment, especially in the nature of sexual harassment to any child from a person that's an adult, it's dangerous. I don't necessarily disagree that it might be a rise to the charge of a 1 year, like that might be a way to do it. To me, harassment is almost an event along the chain of these items that are outlined, whether it be exploitation, then the harassment, then manipulation, and then eventually it could become a sexual abuse. To me, that's why I think harassment is warranted in this context. But I respect your thoughts. I don't think that it's going to open up the doors for a lot of DAs to go chase down 19-year-olds that are dating 16 and 17-year-olds. Could be wrong, but I don't think that's something that most DAs have a lot of excess time to go spend their time doing. But if it's an egregious situation that's been described by my friend here, I guarantee you there was probably some harassment that occurred prior to the other things that he outlined. Obviously, subject to final conviction or whatnot. The accused has not been proven guilty yet. But I'm not an attorney. I'm just a person that advocates, especially for children, which I know we all do.
Mm-hmm.
And to me, I think there's a dynamic where adults, especially with the use of technology and communication, that there's a new form of harassment that did not even exist or was not contemplated in code from 20, 30, and 40 years ago. So that's just my thoughts as to why the use of harassment would be something that can be additive to the DA's discretion. And I'll yield at that. Thank you.
Okay. All right. Okay. You three were all lit up, and then you all went black. So, who wants to talk? You want? Okay. There you go, Representative. You're.
Thank you, Madam Chair. Thank you, Madam Chair. I'm looking at lines 11 through 15, and then it's again at 16 and then 19. Are these, you are grooming when these actions happen from lines 11 through 15, but line 16 says you have to make contact for the whole sole purpose of grooming. I guess my question is, is that the case? If it is, what about the situations where you have someone in a position of trust that turns into grooming? They did not start the process intending to groom them. It went down that path. Would the person then be able to say, look, we were just there and then it just happened and now it happened? So do you have to start the process? I guess I might summarize the question. Does that initial contact have to be for the sole purpose of grooming, or can you groom somebody who you had a previous relationship with? Well, is that what that says? Because it says a person commits the crime of grooming when such person makes contact with a minor to establish trust for the eventual objective of arousing. My question is, you could have a teacher or a coach or somebody that has a relationship. It did not start with the purpose of grooming, but now it has turned into, I'm going to start grooming you. it didn't start, not me, of course, but it didn't start with the purpose of starting that trust. I mean, as long as the language is fine, I'm fine. I just want to make sure that someone doesn't get into court and say it just happened, because we had that relationship already. Does that make sense? I'm not crazy, right? All right, thank you. I am crazy, but thank you.
Okay.
I just would love to tighten that up personally, if you can.
Okay. All right. Representative, you had a question?
I do. Thank you. And thank you, Mr. Chair. I love this bill. I thought this was already codified, honestly. But I do have a non-attorney question for the attorneys. I'm a little confused about the whole contingent on a conviction thing. So if you have an 18-year-old who's dating a 16-year-old and they date for 2 years, they don't consummate the relationship until she's 18. Can the 18-year-old who started off at 18, can he be charged with grooming in that case? Because it started with the intent of arousal, I would say, at 16, and they wait until 18. Is that grooming? And do we have people who can fall into that situation and get charged?
Why don't we have Pac step up? Dr. Scandalakis, I don't know if you would like to say something or.
Madam Chair, the expert for PhD is Elaine Briones, and I'm going to let her, because she studied this, she knows more.
Prosecuted it. Yeah. So, you've got the floor.
Okay.
Yep.
So,
And also, if you would, because I think a lot of the committee members are thinking of enticement
yes.
whenever they're thinking about grooming. So you might want to speak to the differences, because I know, Darshan, whenever you had that question about what's the closest thing, I was thinking obviously enticement of a minor for indecent purposes. So if you could just speak to the differences between this offense of grooming versus enticement, and then kind of go on to the different things that you would need to prove as a prosecutor. So.
Okay, so the two offenses that I would think would be somewhat similar to this would obviously be enticement. Enticement of a child requires asportation, though. So
It requires what? I'm sorry.
asportation, movement of that child.
Okay.
So pretend I'm a defendant, I'm in my car, and I entice the child to go somewhere else, to my house or to a playground for the purpose of child molestation. That's enticing a child for indecent purposes, but that requires asportation. This offense is conducted primarily over social media, text messages, computers. So the other offense that could be similar is also criminal attempt to commit child molestation. So whenever you commit an act that is a substantial step to committing the offense of child molestation, whether that is communicating with a child through text messages to get them to be alone with you, that's a substantial step if you complete the act. Well, you don't have to complete the act of child molestation, but once you complete the act of asking them to meet you through whatever means it is, and with child molestation, because it's just a substantial step, you don't have all of these specific elements. It's based on the facts of that case. So it's going to be quite easier to prove, quite frankly. So if I had something like this, the situation that was described earlier, I would charge criminal attempt to commit the offense of child molestation. The way I read this bill, and I'm working from LC 481019, this is a standalone offense. It does not require a secondary offense or a conviction for rape or child molestation. What has happened is over the past year, several states have enacted grooming statutes, which have been standalone bills. The one state that comes to mind more than others is Texas. Texas, their bill went into effect September of 2023, and they passed that bill as part of an effort to prevent human trafficking, because this is how traffickers find their victims and gain their trust. Grooming is a pattern, so when we look at the actual the elements of the offense, makes contact with a minor, Grooming is actually a pattern of behavior. And the other statutes I've looked at, you know, in our statute, line 16, it says a person commits the offense of grooming a minor. In many statutes, it says an adult commits the offense of grooming a minor. So they make that distinction between an adult and a minor. So that's one change that that I would recommend. And when we talk about contact again in line 16, that phrase is very broad. This could be challenged as being overly broad. So you're going to have to define what that contact is, what that pattern of behavior is. And I would recommend looking at other statutes from other states. And PAC is always happy to work with Representative Powell or anyone else to come up with some language. But it is a standalone offense, and as it is drafted currently, my only concern would be right now that it may be overly broad because the phrase contact is not clearly described. There's not a definition that we can go to, because due process requires us to tell the defendant exactly what act we're prosecuting him for.
Okay. All
Have a
right.
follow-up?
Yep.
So, with that being said, my situation with the 18-year-old and 16-year-old, the 18-year-old could get charged with grooming.
If they're an adult. Well, in this bill as it is, yes, because it's a person.
Okay. All right. Question over. Okay. You're
Thank
on.
you. I'm using his mic because mine is malfunctioning.
Okay.
That's okay. Okay. Thank you. So I agree with Representative Hutchison that I like the idea of the bill, but I am an attorney, and so I always like to be very specific, particularly when you're talking about the criminal code, because the prosecutors are going to have to prove every element of it in order to get a conviction. So not only the line 16 that talks about contact, but I like for language to be similar in the criminal code, just so it's consistent with across the code section. So the language eventual objective sounds like the word intent, and somebody tell me if it's wrong, but it sounds like the word intent that we use in the criminal code to be more consistent with the criminal code and the element that you would have to prove with that. So that's my only, I guess, question, is to confirm that eventual objective means intent in the criminal code and suggest that at the appropriate time.
Okay. All right. Thank you very much. Do you want to respond to that, or?
I would agree with that.
Okay.
Because you have to prove intent, scienter.
Mm-hmm.
But for other recommendations that PAC noticed, if this bill is intended possibly to prevent human trafficking as well, as it is drafted, it would not include a trafficker, because right now this bill says arousing the sexual desire of either the minor or such person. So it's just the person. If you wanted to include a trafficker, you could at the end of line 18 add, or committing the offense of trafficking of persons for sexual servitude as provided in code section 16-5-46.
Okay. All
And
right.
the second recommendation would be to add texting specifically. I had a district attorney talk to me about a case in his circuit this summer, and what we had was a 16-year-old who was contacted by a teacher. He was text messaged with some sexual comments. The teacher was in Nashville, the student was in Florida.
Mm-hmm.
Text messages. So what we did with regard to research was electronically furnishing obscene material to a minor, 1612-100.1, wouldn't have been applicable in that case.
Okay.
Because it says it doesn't apply to text messages. So we then went to 1612-100, sexual exploitation. That didn't apply at all either, because it dealt with photographs and medium, not texting, not words. Then we moved to 1612-100.2, which is computer electronic child pornography, and that also only deals with audio, visual, and imagery. So there is a hole in the law when we're talking about text messages.
Okay.
So I would recommend that, and I would also recommend adding a venue provision that
Okay.
is similar to the venue provision in OCGA 16-12, 100.2, computer child exploitation,
Okay.
subsection H.
Yeah. If I could just, we still have numerous questions, and I am heartened by the engagement of the committee. However, I do feel like that this bill needs some more work. Just kind of from what I'm gathering from from committee members and from witnesses and PAC, and Chairman Powell is obviously very is wanting to have a good bill, and I think a tight bill. So why don't I'll coordinate something, and we'll kind of get together and hopefully get a committee sub worked up that would encompass some of these, and we'll circle back as a committee and hopefully address some of these concerns. I've been taking some questions. I've been writing down some concerns. Obviously, if y'all have specific concerns, feel free to shoot me an email, and I'll tell you when we're meeting. There's no secret squirrel meeting, but I can tell you when we're meeting. So if you'd like to sit in on that, yes.
Just a clarification, do you think in today's society that we should consider also, what is it? Social
chatting,
media,
talking messaging.
like there's text messaging, kind of, but like you got direct messaging. She just said chatting, like how
DMs.
Yeah, details do we need to consider?
I think this current language is pretty broad. It says
Contact online.
Yeah,
Commute
any
online.
communication. So
Well, then text should be included.
Yeah.
Just as y'all consider to perfect the bill,
Uh-huh.
how specific do you need to be in those forms?
I would say this: there are other provisions in the code, and I would look for sections that deal with electronic communications, because that will deal with cell phones and texts and all of that, just to make it consistent. We do have provisions in the code for what we call electronic communications.
Okay. All right. Sounds great. So that's the posture. I'll circle back with PAC and circle back with you, Chairman Powell, and
Madam
we'll.
Chairman, I want to thank you and your committee for this, for the positive impact of this.
I'm
Thank
always
you so much.
I am always in awe of the passion with which my committee members attack some of these issues. So I am very, very heartened by that. But for now, we're gonna table this, and we'll hopefully circle back with a good committee sub. And now we're gonna recognize Chairman Saines. We have one more bill. Ladies and gentlemen of the committee, we just kind of sprung it on you on the last minute. We are looking at House Bill 1022 by Representative Saines, LC 49-1685. I will say that the hour is growing kind of late, so this is going to be, this has been very well vetted in judicial non-civil, so this, I'm not anticipating a lot of controversy, but one never knows. So I will recognize Representative Saines to present the bill.
Thank you, Madam Chairman and members of committee. I'll be quick with my information on the bill. As the Madam Chair has mentioned, this had passed unanimously in the Senate several years ago and brought by former Senator Sheila McNeil and her policy associate Leslie Manukian, based on a constituent in Camden County. Colton, the son of Carrie Ann Montgomery, was unfortunately the victim of a caregiver, and I would mention the 2-year-old child at the time was a nonverbal child who was a victim of a caregiver's abuse. The individual served about a few months of his sentence. So this would address the fact that cruelty to a child who's a disabled minor is a even more heinous instance of abuse, and recognizes and codifies it. What it would do on lines 53 through 57 is increase what currently is 5 to 20 years for first degree, and 1 to 10 years for second degree, respectively. It would increase it to 15 to 30 years and 10 to 30 years. And that is the crux of the sentencing modification. And then, of course, the definition of a disabled minor is defined through lines 16 to 24. And that is the policy intent and kind of the structure of the legislation.
Thank you very much. Members of the committee, do we have any questions? Seeing no questions, I'm going to recognize you for a motion.
Thank you. Madam Chair, I'd like to make a motion to pass.
There is a motion to pass House Bill 1022, LC 491685. There's a second. All those in favor of passage of the bill, please signify by saying aye.
Aye.
Any opposed, like sign? Congratulations. That is without a doubt probably the easiest anyone has had in juvenile justice in years. So congratulations.
Well, and thank you, and I would like to thank the chair for helping in terms of redefining these definitions of of a disabled minor several years ago. So thank you for your leadership there as well.
Thank you. And on that note, we are adjourned.